Hi, this is January 16th, and we're here doing a workshop at the Dale Law Firm today, and we're going to be talking about third-party special needs trusts. For those of you that are watching online, if you have any questions, please put them in the chat box, and Amy will be monitoring that. And as we get to the end of the program, then Amy will take your questions. For the folks that we have in the audience, once again, if we can hold the questions till the end, partially, almost always the question will be answered in the next slide, but we'll figure out how that works here. And anyway, I want to thank you for coming here, and we're here to talk about special needs trusts. Okay, so part of this is, and for those of you that are watching this, there's a link for a guide that you can download. So you're going to notice throughout the presentation here that it'll refer to specific chapters of the guide, and basically that'll be the handout as we go through this. I want to start off a little bit with one of my favorite subjects. It's a little bit about myself, how I got into this, and how the Dale Law Firm came about. Now this picture you see up here, that's a picture of Agnew State Hospital. That building is now rubble, probably as it should be here. But the reason I wanted to start off with that is a couple of things. Part of this is when we are talking about special needs trust and community living, it really comes from deinstitutionalization here. The other part of that is, just to give you a little bit about my background, is that, as I like to say, nobody joins the disability community willingly. Most of us were drafted in one form or another. Very few of us have really volunteered for that, and I'm pretty much in the same boat. I actually come from a family of institutional workers here, and the picture that you see here is that the fellow there with the bald head sitting in the back, that's my father. He worked in Agnew's Hospital, Napa State Hospital, worked in institutions for over 40 years as what's called a psych tech. It's a form of a psych nurse. The fellow sitting with the baby, that's my grandfather. He worked at Agnew State Hospital working the farms, and he worked there for 35 years. The fellow with the hair and the mustache, that's actually me. That was a few years ago here. I actually worked as a psych tech and worked in a number of state hospitals and institutions for 17 years. That little fellow down in the foreground there, that's my son who's in his 40s. He did not follow the family tradition, so he did not work in psych hospitals. But basically, the reason I got involved in this is that, in the days, and my family was very involved in deinstitutionalization here. Before deinstitutionalization in the state hospitals, here it was very common that families actually lived in on the grounds, or would bring their families there. I used to spend a lot of my time on the grounds of the hospital here. I had always told myself I would never follow in the family footstep, but I decided that I would go to nursing school and maybe work for a couple of years. Well, 17 years later, I did leave nursing, and I got involved in civil rights work and started working at the Disability Rights Education and Defense Fund to work on deinstitutionalization and that sort of thing. And the way I got involved in special needs trust is that as I was doing this work, they didn't teach you in law school or even nursing school anything about public benefits or that sort of thing. But we used to get fairly large settlements for our clients, and my directing attorney one day told me I was going to learn about these special needs trust things. And I got involved in doing this, and what I found is that that I really enjoyed doing special needs trust work. And the second part of that is that part of special needs trust work is more than just preserving public benefits, but it is really ideally, and I hope this is what you get out of this presentation, is that a well put together trust is going to be a trust that's not just going to focus on public benefits, but really focus on quality of life. So really, our focus here at the Dale Law Firm is to create sustainable private social service systems that will adjust to any of the inevitable changes in services. I like to call myself the Forrest Gump of deinstitutionalization. I didn't write the ADA, but I worked at DREDF when they put it into place. I didn't write or was involved with IDEA, but once again, I was there when it shortly after was put into place by DREDF. I met with a lot of folks and really have observed firsthand the change. And what part of this is, and what I want to share with you is the successes of deinstitutionalization, but also the challenges that it brought. And that'll bring us back to why do we do special needs trust in the first place. And part of that is, once again, to provide quality of life and also to fill in the gaps that the government doesn't provide. So part of this is I like to begin these programs kind of defining what it is, what is the challenge that we're trying to meet when we're doing a special needs trust, and if you work with a group like the Dale Law Firm to put your trust together. So the way I like to look at this, whenever you talk to somebody about what is a special needs trust for, universally you're going to get the answer that the purpose of it is to protect eligibility for public benefits. And part of what I hope you get out of this is that, of course, public benefits can be important, but I think in all too many cases, what happens is people focus so much on preservation of benefits, they really miss the big picture, which is the real focus we should have is really focusing on getting the best quality of life we can for the person we're trying to provide for. Focusing only on preservation of benefits fails to address the big picture, and in some cases, I've seen special needs trusts actually be harmful in cases where the focus is just only on public benefits, and really, once again, the benefits are only a tool that should never be the objective. The true objective should be maximizing the quality of life for a person with a disability, and that's what we're really going to focus on. I'm hoping also one of the things that you'll realize as you work with this is that we're a very specialized firm. We only do estate planning for persons with disabilities. I know DJ is here and maybe he can help confirm this for me. My understanding is about 98% of our clients have somebody with a special need. Every so often somebody walks into the office that doesn't have a loved one with a disability, which just totally confuses the staff. So really, our involvement is just working with folks with disabilities, and with that, we do an enormous amount of work, not just setting up the trust, but also counseling trustees and advisors on this. And so really one of the things you have to look at when you hire an office, whether you're hiring the Dale Law Firm or another office, is you're not just buying a document, you're buying the experience of the law firm. And that's one of the things I think that we do a great job here, is that, as I'm going to share with you later as we talk about some of our staff are very involved as advocates in their own right and very focused on really quality of life for persons with disabilities. The objective of most of the families we work with really is to provide their loved ones with the best quality of life possible for a loved one, and a life that promotes independence and is free from neglect and abuse. And we're going to talk a fair amount about the challenges that many people in the community have, and the sad incidents of abuse and neglect that is often experienced, and how, once again, you can use a trust as an advocacy tool as well as preserving public benefits. Once again, maintaining public benefits is merely one tool in pursuing a broader goal. Now, for some of you that are watching this is not going to be hard for you to imagine, but I always like to illustrate, special needs trusts and the challenge that we have with these trusts by introducing you to Kathy, okay? Now, so once again, imagine that you have a daughter named Kathy who has a significant disability, okay? And imagine that she's 17 years old and she's likely to have needs at some level for the rest of her life. Now, this is one thing that, my friend Brian Rubin, who's an advocate for folks with autism, one of his favorite sayings is, if you've met one person with autism, you have met one person with autism. Now, for me, it would be a lot simpler if they were all the same, but that's not the way it works. Merely having a disability doesn't mean that, once again, they need a tremendous amount of assistance. There's a lot of self-advocates who are able to advocate for themselves and probably wouldn't appreciate somebody doing it for them. Once again, there are a lot of folks with disabilities who are probably going to need some level of assistance, and there's some folks that are going to need complete oversight for the rest of their life. So you always have to gear this to the individual themselves. But let's just imagine in this case that we know Kathy is going to need some sort of level of assistance for the rest of her life. So you come to the estate planning attorney here. So let's say you come to the Dale Law Firm and you get one of these clever special needs trusts done to provide for her needs in the event of your incapacity or death. And as we're going to talk about, special needs planning is not just death planning. It's also planning if, as the advocate parent or family member, what happens if you're not there to be the advocate? So you come into that to provide for her needs, and you get your plan done. And let's say Kathy is otherwise healthy and is likely to live for another 70 years. Okay, because actually she's supposed to live until she's 87 years old. So let's say that once again, shortly after you put the trust together, so drive safely out there, because there's a lot of bad weather, so we don't want this happening to the folks in the audience here. Let's say that you pass away in a tragic accident and Kathy's 17 years old. What are the kind of challenges we're going to face for the next 70 years? First off, I'm going to go through a whole segment about the benefits, about the basics of public benefits, okay? According to 2020 law. So for the folks in the audience, how many people think the benefit laws will stay the same for the next 70 years, right? And I've never had anybody paying attention that's put their hands up, and we actually have an advocate out here who does this work, and he didn't put his hand up either. So benefit laws not may change, they're going to change. So if we do a trust that all it does is preserve your public benefits in accordance to 2020 laws, did we do our job? And the answer is no. We need to anticipate that laws are going to change, and we better make sure that document is going to be able to change as those laws change as well. Social service systems will change. One of the questions I get all the time is, how much should I put into my child's special needs trust? Now, I actually wrote an article, and in 6 pages, I basically took the time saying, how in the hell could I possibly know? The reason being is, if the purpose of the trust is to supplement the programs that Kathy's receiving, and let's say she's a regional center client and getting pretty decent benefits and services, and if they stay in place, which is incredibly unlikely over her lifetime, maybe her needs would be fairly minimal. Let's say like the mental health system here, where the entire system collapsed, because in the early days, all the money was in mental health. And it's all, and once again, right now, our mental health system in California is, what would be a good term? Disgusting. Here, once again, you're starting with a baseline of 0 of services, and once again, you basically are providing virtually everything. So social service systems will change, and this is one of the reasons for you advocates out there to always be involved with NAMI for mental health, the ARC for developmental disabilities, the CILs or whatever, because what we have and anything we're going to have is because of advocacy by parents and persons with disabilities. Because once again, don't you believe that both the federal and state government would love to cut programs as much as they can, and they're really working on it over time. Her condition may change. These folks are not static. So she may get better, she may get worse, there may be different treatments, whatever, but these folks are not static. The chances are that she will change over time. Her advocacy system definitely will change. One thing I will say almost universal with most of the families we work with is that they are the primary advocate for their disabled loved one. So the issue is, and of course we can't replace that advocate parent, but the issue, of course, is how are we going to have some sort of advocacy system out there that's not just going to make sure that she has a roof over her head and gets her benefits, but make sure that she's free from abuse and neglect, and also is living the best life possible. Attitudes may change, and attitudes about disability have changed dramatically, and we're seeing them change both for the good and for the bad here, and that certainly can change her world and services that may be available to her. The amount of resources she needs may change. Once again, trying to really pinpoint how much she needs is an almost impossible task because there's so many variables out there. And so, and part of this is when we do trust administration, we try to project out what the needs are as best we can, but we must always be going back and looking at it over and over and over again to test out our assumptions, because of all these different variables, it's really hard to tell here what resources she needs. And of course we have to work within the resources that are available by the person that set up the trust. Trustee options will change. One of the things I'm going to spend most of my time on, or a great amount of my time on, is choosing the right trustee. I will tell you, for any special needs trust practitioner who does this work, you're going to come to the conclusion that the management system of the trust is the greatest issue you're going to deal with about whether or not this trust is going to succeed or fail. So as we go through our 4-point process here, once again, here we're going to talk a lot about trustees and different options and different models. So, focusing only on benefits ignores what may be the greater issue, with that persons with disabilities are often subject to abuse and neglect and require a great amount of vigilance. Now, really, for those of you that are watching, even if you have a child that's nonverbal, there's usually behavioral clues or that sort of thing you're going to pick up that maybe other people aren't attuned to, that really are going to indicate when something's wrong. I know most of the families, and I was a behavioral nurse when I was a nurse here, and you learn to pick up those cues. That's not something that everybody is really in tune to. And once again, and statistics seem to show that actually living in the community is more hazardous than living in a facility. That doesn't mean that we should move people back into facilities, but with community living, it does have its own challenge, and abuse and neglect is a big thing we have to keep an eye on. It's also often essential to be vigilant for signs that their loved ones are not being abused or neglected. And I know with a lot of families we work with, that is one of their biggest concerns, is that of course nobody is going to be as good an advocate as the parent or a close family member. But what we're looking at is, how can we do the best we can to be able to fill in that gap? Now, as we're talking about setting up trust and really talking about the challenge, I always like to introduce this person, Ed Roberts, somebody who had a great effect on my life. I was privileged to be one of his many, many proteges before he died in 1995, and he had a great effect on my life. But one of his favorite sayings is that the disability community does not discriminate. It will accept any of us at any time. So the point of that is that a lot of people look, and we get a lot of folks that will come in and say, well, I want to get one of these special needs trust things done, so if I died, as if you're going to get out of this thing alive, I'm going to make sure that my loved one gets to preserve their public benefits and that kind of thing. But the bigger question, and sometimes the harder issue, is what if you have a stroke? What if you get Alzheimer's? What if you become disabled? How are you going to allocate your resources between your needs, your loved one with a disability, other family members, your spouse, and that kind of thing? And when you're doing your planning and sitting down with Jennifer and her drafting team, and we'll talk about that later, that's one of those things that you want to address and you really want to keep in mind and make sure that not only with the documents, but also with everything else that we have, that there's clear instructions about how things are supposed to be managed if you become disabled yourself and you're not able to express your wishes. Another thing that I like to address as we get into this, and this comes from a book called Loving Trust. Loving Trust isn't even in print any longer. It's not a book about special needs trust. It's a book about a philosophy of estate planning. But the reason I like to cite this is that their definition of estate planning is that I want to provide for myself and my loved ones during my lifetime, and upon my incapacity or death, give what I have to who I want, the way I want, when I want, and if I can, save every last fee, tax, or court cost possible. Now, my clients often will point to this. They're pointing to the fee part here, but if we kind of bring you back to the totality of this, is that estate planning is not just death planning. Whether we're planning for a person with a disability or we're just planning for yourself, it's also taking better control of your assets and putting instructions on your assets in the event that you become incapacitated. And we're going to certainly cover that a bit. So, once again, I know I spent a lot of time talking about we shouldn't just focus on the basics of benefits, but it's kind of hard to talk about a trust that preserves public benefits if we don't talk a little bit about public benefits. So I'm going to walk you through, I'm hoping for about 20 minutes here, about the basics of public benefits, and then we can talk about how the trust works with those benefits here to preserve them. So there's basically two types of benefits we're dealing with. The first are what are called needs-based benefits, and those are things like SSI, or Supplemental Security Income, which is where we're going to spend the majority of our time, Medi-Cal, food stamps, legal aid, utility payments assistance, HUD, or Section 8, or what I like to call the bad boy of disability benefits, but we'll get into this, certainly essential here. And what's common with those programs is you have to show a need based on disability and limited income and resources, and that's why they're called needs-based benefits. The other kind of programs we're going to talk about are Social Security disability insurance, childhood disability benefits, which is very common, especially for folks with developmental disabilities, Medicare, and special education. Now, what's common with those programs is, yes, you need to show a need based on disability, but you could win the lottery and still stay qualified for these programs. They don't have any unearned income limitations, nor do they have resource limitations. And that's one of the major differences between those programs. Another way to look at this is our cash assistance program for our needs-based programs is SSI, or Supplemental Security, and tied to that is Medi-Cal, okay? Our entitlement programs, our cash entitlement programs, are either Social Security disability or childhood disability benefits, and tied to that is Medicare. Many folks on benefits eventually will get all four programs, and we'll talk a little bit about how they work together, more or less. So let's start off with SSI. What is SSI? SSI is a federal program administered by the states, and it's based on showing the sufficient evidence of disability and financial need. It's intended to pay for food, clothing we don't count any longer, and I'll go through why I bring up clothing, and shelter, and nothing more. And for $943.72, you're supposed to pay for your food, clothing, and shelter in California. Good luck with that. Okay, once again, imagine trying to live on that amount of funds. And really, it's so far below the poverty rate, it's just really crazy. There was some place in Mississippi up until a couple of years ago where you could actually live above the poverty rate on the SSI rate, and that's no longer even true. So it's one of these things where even when you qualify for the SSI, it certainly, can you just imagine trying to live on that amount of money? That's just baffling to me. As I say every day, I would never want to be one of my own clients. So for SSI, there's a three-part test. Okay, so the first test we're going to go through is you've got to meet the definition of disability. The second test is an income test that determines how much you receive. And the third test is a resource test that determines whether or not you're eligible. So let's go through those tests. So as far as meeting the definition of disability, and I remember when I was working with Ed, he found it really funny that, I told him, hey, Ed, when I started learning about this, I just discovered you're not disabled. Despite the fact he was quadriplegic, dependent on a respirator for the rest of his life, he wasn't disabled, and we'll go through why. So the definition of disability isn't just having a diagnosis. There really is a functional test. So a benefits recipient has to be a person who's under 65 who has not been able to engage in what's called substantial gainful activity because of a medically determinable physical or mental impairment that's expected to last a year or longer or end in death. In 2020, basically, the rule is if you can earn consistently more than $1,260 a month, you are not considered disabled. Okay? So, and this one thing, we don't do disability determinations, but a lot of folks here, oftentimes they'll get denied because they focus way too much on the diagnosis. But what Social Security is really focused on is this functional test. Can you earn consistently more than $1,260 a month? So the second rule test is the income test that determines how much you receive. So there are three types of income we're going to talk about. Okay, so the and really I'll start off by introducing my niece, whose name is Erica. Erica has Down syndrome, lives in Bayshore, New York. She's somebody we very much care about, and we've actually set up a special needs trust for her. And let's just say with Erica, we don't want to do one of these special needs trust things. I think what we're going to do is we're going to buy an annuity, and what we're going to do with that annuity is we're going to make sure the annuity pays her $100 a month, so she could use that money to do whatever she wants with it. Well, here's the problem. If she gets any cash or payments from annuities or pensions or alimony payments or dividends, interest, rents, awards, or any payments even from another disability program, it reduces her benefits dollar for dollar after the first $20, called the $20 disregard. So here's what would happen if that's what we did. They would let her keep the first $20, and then they would reduce her benefits by $80 a month. So that illustrates for people that are on SSI, you cannot give them cash, okay? The second kind of income is earned income. So let's say Erica earns $265 in the month of January. Here's what happens. They don't count the first $65, but then they would take their remaining $200 and they would reduce her benefits $1 for every $2 she earns. So she would get to keep $165, but her SSI would be reduced by $100. By the way, we hear this all the time that people on SSI cannot work. Absolutely not true. There are what we call cliffs. And I will tell you, for those of you that are really interested in finding out more about a person with a disability working, the best place to go is a website called disabilitybenefits101.org or db101.org. Fantastic website here with calculators that will tell you how much you can work before you go off the cliff. Here's the most perplexing thing that comes up. Let's say that you say to your child, you can live in my house and you can eat my food, and I'm not going to charge you anything for food and shelter. Okay, here's what happens. If somebody is assisting them with food or shelter, it could be a family member, it could be a friend, it could be a trust, it could be any number of things. What happens is SSI will reduce their benefits dollar for dollar, capped at 1/3 of the federal rate plus $20 just to confuse us all. So what would happen is if you do not charge your child fair market rate, and in some cases that's not possible to do, and you're assisting them, what will happen is their benefits will be reduced dollar for dollar for the assistance, capped at $281. I know that is the most perplexing thing around, and for those of you that want to learn more, we have a video specifically on housing. That's probably one of our most favorite videos, and it also goes through on how you can use an ABLE account, which is not today's subject here, to really minimize that. But once again, the third kind of income is if you're providing food or shelter to an SSI recipient, their benefits will be reduced dollar for dollar for the assistance you give them, capped at $281 in 2020. There's usually a slight increase every year. There's a cost of living increase, just enough to make me have to change my slides every year. So the third test is the resource test that determines whether or not you're eligible. So what is a resource? Anything you can convert into cash for support is a resource. The benefits recipient can convert into cash. And if the resources succeed, and it's literally $2,000 on the first moment of the first day of the calendar month, they're not eligible for SSI that month. That's a very hard and fast rule, and it's something we always have to be aware of. Now, there's huge exceptions to this, and I will tell you that housing is probably the biggest issue we deal with, second to nothing. You can leave a person who is on SSI or Medi-Cal a home of any value that they can live in, and it won't count against their public benefits. For any number of reasons, we almost always counsel people to not do that. But once again, I would refer you to our program on housing about why and different options. But if you decide to do it, you could actually leave a person on SSI a residence they live in of any value, and it won't interfere with their benefits, although they're going to have to maintain that thing on $281 a month, which is going to be a challenge. In that house, they can put all the stuff they want, and the law changed as of March 2005. Here, all the household goods you like, including clothing, here, and that's not a problem. So big screen TV sets, no problems and that kind of thing. The only restriction is you can't hold things just for their intrinsic value. I had a fairly infamous case I worked on a while back where somebody had a box which looked like a bunch of junk to me, but it was a bunch of bobblehead dolls, and they were worth $40,000, and no, you cannot have $40,000 worth of bobblehead dolls, although one was a Barry Bonds bobblehead doll, and I think it's probably worth a lot less today, but it was worth a lot back then. On SSI, you can own one automobile of any value here, and once again, there used to be a restriction on the value of that, but that changed in 2005. You can have items related to the disability. That really does make sense. This one is kind of an odd one. The person with the disability can own a life insurance policy with a cash surrender value of no more than $1,500. Now, if there's any financial advisors out there, you're probably scratching your head and going, what would that look like? That'd be like a whole life, variable life. I mean, if you were, these numbers are horribly out of date. They were established in the 80s. You're never going to see anything like that. But by the way, that's not what the parents, oftentimes parents will fund these trusts with insurance they own. That's not what we're talking about. We're talking about the beneficiary the benefits recipient can own. They can own a term insurance of any value because it has no value until they pass away. They can also own a burial plot of any value. So that would include a plot or a crypt or whatever, but they can only set aside $1,500 of their own money to get into the space. And by the way, if you've priced out the market, that's not going to be a real fancy funeral or whatever. So once again, and by the way, a special needs trust can fill in that gap. So the thing with that is that the SSI is certainly important here. But oftentimes when you're looking at the value of preserving the benefits, it's really not the SSI. In many cases, it's the Medi-Cal, referred to in other states as Medicaid, that's important. So if a person on SSI receives at least $1 of SSI, in most states, including California, you would be categorically eligible or automatically eligible for Medi-Cal. I want to mention that is not the only way to get qualified for Medi-Cal. So I've seen cases where people have gone to extremes to preserve that last dollar of SSI. It actually is not necessary. There are other ways to qualify for Medi-Cal, but once again, if you qualify, if you get at least $1 of SSI in California, you automatically qualify for Medi-Cal, and there's no further application needed. Now, as far as Medi-Cal, once again, it's a federally funded program administered by the states. It has once again, it basically has the same eligibility rules for disability-based Medi-Cal as SSI. It's essentially the same. But there are other ways of qualifying if you're not doing it because you're getting SSI through programs called Aged and Disabled Medi-Cal. And because we can't go into all the different programs, once again, there are different ways of qualifying for Medi-Cal, but you still have the $2,000 resource level if we're doing disability-related Medi-Cal. Part of what Medi-Cal provides is in-home hospital service treatments, outpatient hospital service treatments, home health care, which would be things like in-home support services. I think for many of the beneficiaries we work with, in-home support services is an absolutely essential program, even though they pay their workers a crazy low amount here. Pay for physician services, laboratory services, and x-ray services. They can pay for transportation and medical care. In California, we also provide dental care, although I will tell you, for a lot of the beneficiaries we work with, it's really common that we'll end up paying for the dental care privately. And many regional center services are actually based on Medi-Cal eligibility. So for many folks, this is an essential program to maintain. For some folks, it's not as essential. Oftentimes when we're doing planning for folks, we might be hiring an outside consultant to tell us what is the value of the Medi-Cal so that we can make sure that what we're doing is making sense. So let's go through the first of our our entitlement programs. So the first one I'm going to go through is Social Security Disability, which is a national program for injured workers. And so if you have the requisite number of work credits, you would qualify for this. SSDI has no income or resource limits as far as unearned limits. So you could win the lottery, you're still going to qualify for SSDI here. But, once again, earned income could cause an ineligibility for benefits because, once again, it's under the same rules, the SGA rules here that, once again, I believe the SGA amount right now is $1,260 a month. Once again, a great place to look when you're looking for more information about this is the disabilitybenefits101.org website, maintained by WID, which, by the way, was established by Ed Roberts. The program that oftentimes we're dealing with when you're dealing with a disabled loved one is the childhood disability benefits. So childhood disability benefits used to be called DACs, is if a child was disabled before the age of 22, they may be eligible for benefits themselves based on their parents' earning record. Benefits are not payable until the eligible parent dies, retires, or becomes disabled themselves. And Social Security is not affected by the child's assets, but once again, income may result in, earned income may result in ineligibility determination because you're still under the same SGA rules. So going through how this actually works, upon the disability or retirement of the parent, an eligible disabled child will receive an amount equal to 1/2 of the parent's benefit. And upon the death of the parent, an eligible disabled child will receive an amount equal to 3/4 of the parent's SSA benefit. So you know how you get this thing from Social Security from time to time that says, hey, we don't run out of money, this is what we think you're going to get? You can actually use that to calculate when you retire what if your child was disabled before the age of 22, what they're likely to receive. And the cool thing with this is that childhood disability benefits is a lot easier to work with than SSI. So let's go through some examples. Let's say Helen has been disabled from birth and she's getting $943.72 in SSI monthly. Helen's father, Earl, retires and receives $1,400 a month. Helen begins to receive $700 a month. Okay, so what's that $700 going to do to the SSI? Well, it's not earned income. So since it's unearned income, it's going to reduce the benefits dollar for dollar after the first $20. So what it's going to do is reduce the $943.72 by $680, meaning that basically now she's getting $963.20, so she's only $20 to the good. Now you might think, well, what's the big deal here? And I'm going to show you, even at this point, there is a big deal. So we'll get to that slide later. Let's go to the next scenario. Let's say Earl passes away and Helen gets 3/4 of what he was receiving, which was $1,050 a month. Now the math is really easy. If we subtract that from the $943, the amount of SSI will be 0, so it will knock her completely off the SSI. And she's going to lose her SSI-linked Medi-Cal, and she'll have to qualify under a different program. And under this program, under the current rules, she will still qualify for Medi-Cal without a share of cost. But this is one of those things you have to be vigilant because you'd find this hard to believe. Social Security makes a lot of mistakes, and we run into situations all the time where somebody should still be getting their SSI-linked Medi-Cal, and you're still going to be under the $2,000 resource rules and that kind of thing. But we want to make sure that the Social Security does its job and does it correctly. Let's go through the last of the programs, which is Medicare. Medicare is a federal program for people that are over 65, but it's also for people that are under 65 who've been getting Social Security based on disability for 2 or more years. So Helen would start getting 2 years after her parent either retired, became disabled, or passed away. Here would start receiving Medicare. She would become what's called Medi-Medi. She'd get both Medicare and Medi-Cal. And Medi-Cal would pay all the co-pays. So for many folks we work with, especially if they're developmentally disabled, which by definition is before the age of 18, but if the disability began before the age of 22, Here, oftentimes there'll be Medi-Medi, and that's actually a good place to be. Medi-Cal is the payer of last resort, but it also covers long-term care. Now, in some cases, Medicare may cover virtually everything that's needed, but what it doesn't cover is it doesn't cover long-term care. It doesn't cover attendant care, and there's some other programs involved that Medi-Cal does cover that Medicare doesn't. So sometimes, and once again, we have a number of care managers and consultants. We often will have families or trustees hire to really figure out what is the value of the benefits we're trying to preserve, because this is not incredibly intuitive. But once again, being Medi-Medi is a good place to be. So after we went through this, let's just talk a little bit about trust. So a general overview. Before we can explore special needs trust, we need to have a discussion about trust in general. Now, trusts seem like these mysterious things, documents. When I was in law school, they certainly seemed like mysterious documents to me. But in fact, all a trust is a contract to do something, okay? And there's all sorts of different trusts. Some trusts are established for management purposes, some for tax planning purposes, and some are established to provide social goals. So with this, here, once again, there's many types of special needs trust. One that I'm going to cover real quick is a living trust, a very common trust that we use in California to avoid probate. There are charitable trusts here that are used to help a nonprofit and in some cases get a tax benefit back. Insurance trusts, which can be put together so that it's not counted against your state. And we're going to be focusing mostly today on special needs trust. It's a special kind of trust or a contract to preserve public benefits. So, with a revocable living trust, it's a contract you make with yourself or your spouse, here, which controls how your assets are managed while you are alive and how they're to be distributed to your heirs when you pass away. This allows you to take your assets that are either owned by your own trust, that are owned by your trust, or make the trust the beneficiary, and direct how they're going to be managed during your lifetime or upon your incapacity. So it's a way of putting special instructions on your assets by running them through a trust. Now, we'll talk a little bit about the Teresa and Stephen Dale Special Needs Trust. And by the way, this was taken a few years ago here, but that's my lovely wife and basically my business practice partner, and that's me. And so we've done our own living trust for a couple of reasons. One is it would be really embarrassing if we passed and our estate went through probate here, and so we've done our own trust. And part of that is we put into our trust that upon our capacity, it's instruction about who's going to be in charge if both of us are incapacitated, how we want to be provided for. For instance, I worked in an institution. I am terrified of institutions. So my trust basically says, hey, if there's a choice between leaving something to my children or taking care of my wife and I, my kids are going to be fine. Take care of us. And that's literally the instructions it has. I don't have a child with at least a diagnosed disability here, so I can be a little bit more cavalier than my own clients. What kind of support should I continue for people that are dependent on me here? And it really allows me to keep that continuity. Upon our death, it provides protections for the survivor of us. It provides instructions about who's going to serve as trustee and instructions about how to provide for our loved ones as well. So it really operates as a will substitute. And one of the reasons that living trusts are so important, especially if you own a home, is that a trust really works on avoiding probates, because anything that's titled in the trust, so if we take the house and title it into the trust and pass it through the trust, we're passing it through a contract rather than through California law. Therefore, we're not subject to probate, and there's a huge amount of savings here. By the way, it does also provide for causes that are important to the two of us. And I will mention, many of us benefit by the advocacy by many of the disability programs like NAMI, the ARC, Autism Speaks, so many different disability groups, and leaving just even a few dollars to these organizations, man, they're going to really leverage that and help so many people with disabilities. So please try to remember them. In our estate plan, it allows us greater control over assets, both upon our incapacity or the death of either of us. It avoids the cost of an expensive conservatorship if we lose capacity. Once again, we do conservatorships, and once again, along the theme that I don't want to become one of my own clients, by having things managed by our trust, if we lose capacity, we're not going to be having the Contra Costa County courts, which we love, but we're not going to have attorneys and judges managing our affairs. We're going to have trustees that we've chosen to manage our affairs, and it's going to avoid probate because our assets are going to be passed by a contract rather than California property law, which would subject it to probate. So let's, now that we're quite a bit into this, let's talk about special needs trusts. So special needs trust, it's not something that Social Security thought of about how to help families with this. It's something that was put in place, probably the first trust was probably put in place about 35 or 40 years ago here by a number of folks here. And it came from this definition of a resource that Social Security Administration defines a resource for an SSI recipient as cash or any other personal property that they own, that they have the power to convert into cash, that they're not legally restricted from using for their own support and maintenance. The early trusts were really basically set up as what are called spendthrift trusts. Spendthrift trusts have been around for quite a while. Originally, what a spendthrift trust was meant for here was that there was a time when, of course, you would never leave anything to your wife. Why would you do that? You would set up a trust to take care of her because at one time, really, actually, a wife was your property. Well, at this point, my wife has made it really clear she's not my property here, and she's a person of her own right, and she absolutely is. And those days are gone. But a spendthrift trust is basically what a special needs trust is. It's just a glorified spendthrift trust. And so if the SSI recipient does not own the asset outright and is legally restricted from directing access to the funds, those assets are not considered a resource for benefit eligibility. So a special needs trust is a contract where the trustee has sole and absolute discretion over the assets of the trust and the beneficiary has absolutely none. So by the way, for the folks in the audience, do you see a problem with a trustee that has sole and absolute discretion? When I review a special needs trust, okay, about whether or not this really meets the definition of a special needs trust under SSI and Medi-Cal, what I'm looking for is there any way possible that a beneficiary could force a distribution from the trust? If they could force a distribution from the trust, then it would be considered a resource and it's not going to function as a special needs trust. On the other hand, we are taking the most vulnerable person in your family and we are saying that basically, trustee, you have absolute discretion and you have the ability to not to make a single distribution for my child, and that's what's required to make that work. Okay? So as we start talking about trustees, we're going to talk about a checks and balance system to make sure that there is some accountability if we do have a trustee who decides they're not going to make any distributions. By directing assets that are otherwise intended for the individual into a special needs trust, you're preventing those assets from being counted as an available resource, thus preserving his or her eligibility for benefits. And that's how it works. Now, a special needs trust, what they call them in Social Security are third-party trusts. And we're talking about estate planning trust today. We're not talking about what are called first-party trusts, which is when we're dealing with a settlement or that type of thing. That's not our subject today. Our subject today are estate planning trusts. And a third-party trust has great latitude. So you can have multiple beneficiaries in the trust. Since we do so much work with folks with behavioral health issues, you can have the trust that will turn on and turn off. You can have a trust that says during certain periods of time you can give them cash and not. You can do all sorts of creative planning. And you can also leave whatever is left in the trust when you pass away without a lien to anyone you like, with one sad exception. You cannot leave it to the drafting attorney because the state of bar really frowns on that kind of thing. So, and I have some clients that actually like me, but we take our money up front. We don't take it on the back end. So that's how it flies. And I have some clients in the room, and you know we take it up front. We really do. So let's finish with the last half hour, and then we'll take some questions here about the process of creating your estate plan with the Dale Law Firm. Okay, here. And so I'm going to start off with introducing the drafting team as we go through this. By the way, I actually do not draft trusts, so for any number of reasons. One is I do a lot of advocacy work. Also, I'm way too chatty here, so it just wouldn't work. So Jennifer Stenberg here, my associate here, who is a disability advocate in her own sense here. Jennifer worked for 15 years working as Representative George Miller's disability advisor here. She also worked for a major law firm doing access cases, ADA cases. She has a sister with a severe disability that she's the conservator of. She is the president of the EBI. Jennifer, and one of the reasons we're so blessed to have Jennifer is that, it's very difficult to teach disability to an attorney. Jennifer has been virtually living in the disability world her entire life and has been very dedicated. As I like to say, folks, when it comes to disability, they'll either run as far away from it as they can, or as in Jennifer's case, or they'll embrace it. And Jennifer, once again, like many of the folks here, she's embraced it. With that, she works with Lysandra Wilson, who once again has been with us now for, I believe, 12 years or 12, 15. It's been a long time. 16 years. Oh, I should know that. I'm sorry, Lysandra. 16 years here. Once again, Lysandra, who has a JD herself, here does most of the drafting. So those of us that will be working with us through the process, you'll be working with Jennifer and Lysandra. And part of what I want to cover for the rest of the presentation is what is the process of setting up a special needs trust here, and things you should think about before you join us. And that's part of what this is all about, because if you're better prepared before you sit down with Jennifer and Lysandra, then not only will we get a better document, but you'll better understand the process. And one thing about a special needs trust is you're not just buying a commodity. It's not just a thing. These things are living, breathing documents. They're basically operate as a care plan. And it's important, not that you understand all the boilerplate, but it's really understand through the process, not only that it reflects your wishes, but that you really understand at least the basics of how it works. Okay, so with this, we've kind of broken this down into what we call the Achieving Independence 4-step process. The step one is to clearly express your intent in your trust and related documents. Step two, which is where we're going to spend most of our time, is to choose a management system and a team to carry out your intent. You can have the best document in the world that clearly expresses what you want with a really good team, but if you don't put some funds in the trust, it's not going to do very much at all. So the third step is you have to fund the trust. And then the last step, and this is really kind of just reflects the whole disability world, when you're doing planning or advocating for a person with a disability, quite frankly, your job is never done. And that's the same thing here, because even with this, because things are constantly changing, the trust needs to be updated and reviewed periodically during your lifetime and the lifetime of the trust itself. So that's basically the process we use. So let's start off with step one. So with that, what's really common is that many families will want to do what's called a letter of intent. Now, I oftentimes like to call them journals of intent. They're virtually the same thing. But basically, this is a side document that is written to give guidance to the trustee, who may not even know who you are or who you were, but basically giving instructions about what you expect to do. Anytime there's trust litigation, it's always focused on what was the intent of the grantor, the person creating the trust here. And so part of this is that with a letter of intent, and the reason I like to consider it as a journal here is that it's something that you can keep updating. but you're basically, there's really good information that you might want to tell the trustee, like what kind of treatments worked, what didn't, what kind of medication is desirable, what kind of things would you like them involved in. Not just benefits, but it may be, and part of this, one of the tools to avoid abuse and neglect is the more active somebody is in the community, the less likely they are to be abused. So in that case, you might give them guidance about what kind of thing does your loved one enjoy, what would you support, what would you not support. And if you have a bare bones trust that only says preserve my child's benefits, really, then we're not really giving any guidance at all. What we basically do, and the way we do this, and this is part of what you would do working with Jennifer and the drafting team, is the Special Needs Trust itself should have broad information about overall guidance to the trustee and the advocate. So oftentimes, even if you have a small child, there's probably some objectives that you have that are never going to change, right? There are things that are going to develop as time goes on, and you don't want to include everything into the trust because it would just get unwieldy here. But in that, you might want to include something about what kind of living situation would I support, what would I not support. In many cases, keeping close with family ties and things like that are very important. So you might want to express to the trustee that maintaining contact with family is very important. It's important for a number of reasons. One is, the maintaining the contact with the family, but the other part of that is the more people that are actively involved in your child's life, the less likely they're going to be abused, or at least abused, or if there is abuse, it'll be detected. You might want to put something in about your vocational wishes. In many cases, and in some cases, the most successful trust is one that can help somebody get off of these public benefits if that's possible. And so you might want to express in it an interest in vocational training and that kind of thing. Other things you might include is, how to keep it, importance of keeping involved with communities. So for instance, and this is from somebody who's barely Methodist, but it's not okay to put in the trust that if your child doesn't believe in Jesus, they don't get a distribution. That actually could get struck down. It is okay to say that my child and my family are very involved with my church, my synagogue, my temple, whatever. And if my child wants to participate, I want to encourage that. It's not just for the spiritual side of it, but we go back to that. If that's part of their community, it is absolutely okay to say, I want you to do what you can to assist with that. Okay, if that is, once again, something your child wants to participate in. The letter of intent should give more detailed information. That's why oftentimes I like to refer to it as a journal here. But with that, you can get into more detail. And we actually encourage you to begin the letter of intent right away and then just keep adding to it. I've had families who've been doing this for 25, 30 years, and they've actually found it quite therapeutic because they've seen changes in that now they've documented, and that's a good thing to see. Think of the letter of intent as a journal of ongoing documentation of the beneficiary's needs. Once again, it's important in one form or another to express that intent, because otherwise you're going to have the trustee who's going to be guessing what they're needed to do. The quest for the ideal trustee. So this will be the next step. We have been looking for this character for 30 years. And I happen to be the trustee of 200 beneficiaries at the Golden State Pool Trust. I do think very highly of myself, so I would kind of tell you that some of the things we're going to go through, I would give myself a checklist on this here. The last one, if I give myself a check that I could do this, then I'm delusional and you certainly wouldn't want me. So if you think about what the trustee has to do, the skills they should have, and that sort of thing, this is what we've come up with. First off, because the trustee has so much discretion, they should use their discretion in the best interest of the disabled beneficiary. And that's not as easy as you might think. For you parents out there, if you just take a second and just close your eyes and remember who you were before you had a loved one with a disability, I can guarantee you you are not the same person you were before you went on this experience here. In fact, you might not even recognize yourself if you could go back and meet yourself. Disability changes your views on things and your outlooks and that. And the problem I often see is that you might take a well-meaning aunt or uncle here and name them as trustee, but they don't have your experience. They haven't been down the road you've been on. They may do the best they can, but I'll tell you, the most difficult trusts I've seen have been well-intentioned, smart family members who think they understand the needs. I'm here to tell you, it's not as easy as one might think. The other one is somebody who's going to understand public benefits and keep up with changes in the law. Now, that doesn't mean you have to be a benefits maven. Okay, Jennifer and I are both recognized as national experts, but I will tell you, I don't think there's a week that goes by that we are not stumped by something. We know how to look it up, or if we don't know how to look it up, we know how to find somebody who can, and if that doesn't work, we know how to make up stuff, which we're not above that too, and sometimes that's how things are done. But it doesn't mean you have to be an expert. But the things that come up is not just preservation of benefits, but there are some times where maybe preserving the benefits is harmful, and there may be cases where you're just better giving up the benefits. An example would be having to try to live on SSI and pay for your food and shelter versus going ahead and taking the $281 reduction in benefits here and paying for a nicer place, right? That would be an example. Somebody who's going to wisely invest and conform to all statutory fiduciary requirements, meaning this, for lack of a better term, if you have a typical child and you have a child with a disability, it's something we see parents do all the time, and we could do a whole program on this. They want to be equal with their children, and I'm here to tell you, children are not equal, disabled or not, but let's say that's what they want to do, and let's say they buy $1 million life insurance policy, and with it they divide it half to the typical child and half to the child with the special needs trust. Now, if the typical child loses their benefits, what the heck? They have a lot more options. If the money is lost through speculative investments, I just received a trust that I'm going to be working on where all of the assets were on margin, meaning that whoever the investment advisor was doing side bets with the investments with the special needs trust. I'm just going, holy bejesus. We should not be doing day trading or making side bets with a disabled person's money. So we have to make sure that we get a decent return, but we also want to make sure that the portfolio is safe because once again, yes, markets go up and markets go down, but that's really precious money, and if we lose it, there's virtually no way to get it back. Somebody who's going to understand taxes. Now, because we don't have a lot of time, so for the folks in the audience, this may be a good thing for you. I don't have a lot of time to spend on taxes today, which I find absolutely fascinating here. But if we can get a good tax result as well as a good benefits result, then that's really just going to allow us more money to spend on quality of life for our beneficiary. Somebody who's going to keep perfect books. Okay, now Social Security has committed that they intend to review every expenditure of every special needs trust. And a lot of what we do with the Golden State Pool Trust, where I serve as the trustee, is we spend an enormous amount of time not only making the expenditure, but making sure that we record those expenditures because we could be audited at any time. And so really that's incredibly important when you're doing this sort of work. And if you have somebody who is really doing this cavalierly here and just throwing receipts in a box, if you get audited by the Social Security and you just bring those receipts, you're going to lose your benefits. And I have to tell you, the damage to the benefits recipient isn't just the loss of benefits. I have seen people get sick from losing their benefits. I had a beneficiary pass away from the anxiety of losing their public benefits. It's just that serious, okay? So we need somebody who's really going to keep good books. Somebody who's going to provide that advocacy and prevent abuse. That, for me, is really high on the list of priorities. And so we're going to talk about how that might happen. Now, maybe I could do these things, maybe I couldn't. This one's going to be really tough. I got to outlive Kathy, right? I got to be immortal. I have to live 70 years if she became my beneficiary. And there's a pretty good chance, since I'm 68 years old, that I'm not going to be doing this 70 years from now. And at a certain level, I hope not here. So, the thing about it is we need somebody that's going to be there. I have had people sit at my conference room table wanting to name their 6 and 7-year-old nephews and nieces as the trustees, so they would have somebody who would outlive their child. And that's just absurd, okay? So how are we going to find this ideal trustee? First off, they don't exist. But if you look at it this way, we can create the ideal trustee. In my thinking, the ideal trustee isn't a single entity, it isn't a single person, but it's a team. So if you were to take this list, and how you divide it almost doesn't matter, okay? So, because what I'm going for is a checks and balance system. So if we were to put the advocacy things in one box, okay, so that's using the discretion in the best interest of the beneficiary, understanding public benefits, which I consider advocacy because it's not just preservation of the benefits, it's also making decisions when to preserve them and when to let them go, and providing that advocacy and prevention of abuse, which could involve visiting from time to time or really being vigilant. We'll put that in one box. The accountability, the keeping the books, the carrying the insurance, and having some system that is going to be there for the rest of Kathy's life. We'll put that in another sphere. And then the financial part, which would be dealing with the taxes and investments, we'll put that in another sphere. How would that play out? Now, I'm going to go through with you, and the book goes into this more, different models that we usually suggest. Now, if you come to us, you are the clients here. If you say, that's all fine and well, but I'm going to make my daughter the trustee of my bipolar son special needs trust, that's what we're going to do, although what she ever did to you, I'm not sure here, because once again, that is a sibling being in charge of a sibling under the best of situations is challenging. In some situations, it works fine. In some situations, it's a total disaster. If that's what you're looking to do, that's fine. But the reason, once again, hopefully the value of working with our law firm and Jennifer and her experiences, you're not just buying a document, you're buying her experience. And as you go through this, and I would like you to consider these models, part of this is, talk with her, discuss with her and Lysandra, what do you think in this case is? What has worked? What has not worked? And what do you think we might do in your situation? The fun part of this and the terrifying part of this is every client is different and everybody's situation is different. So we don't get bored here. So in this, the first model I'm going to talk about is using a professional trustee with an advisory committee. So with that, we would have a trustee who's going to manage the funds, make the distribution, do the taxes, and keep records. There's a number of different types of professional trustees we use. We use corporate trustees, we use private professional fiduciaries. Okay, so corporate trustees, like for instance, we use Wells Fargo Bank quite a bit. But there are other corporate trustees. West America Bank has been doing this for many years. There's many banks that do this. Many have been in for many years, but once again, these banks do change from time to time. When you're dealing with a corporate trustee or a bank, it's not the bank you're dealing with, it's the people. So once again, we have favorite corporate trustees we like to work with. It's not the company, it's the trustees we work with. And of course, trustees come and go, so that could change from time to time. So we're going to talk about how you'd make that trust. With that, you might have a professional trustee, but my feeling is you should never turn this over to another entity without some sort of checks and balance system. Remember, the trustee has absolute discretion, the beneficiary has none. With that, we might tie that trust to an advisory committee. This is where we might have the family member here. And the way we do it oftentimes is we'll have key family members that might be siblings that would be the committee chair of the advisory committee here. and then they might fill in other people. The function of the advisory committee is to give guidance on distributions, but the other part that almost always we're going to allow them to do is to mend the trust if laws change, and laws are going to change, and also replace the trustee, not just if there's a problem with the trustee. And I'll tell you, when you're talking about trustees and working with beneficiaries, it's a very personal relationship. And, and sometimes the relationship works well. Sometimes we've got to change players. It's not uncommon to do that here. And so it might be that the advisory committee, we want to give them that power if, for instance, it's not working out with that trustee. But the other thing with it is that we are seeing changes in options for administering the trust. So you might have a trustee who's doing a perfectly good job, but as time goes on, there may be a better option that can provide more services at a lower cost. Why would we not want that? Everything is constantly evolving. It's one of these things where we must constantly be on top of that, and we certainly want to, for your loved one with a disability, get the best options possible. With that, we might tie them to a care manager. A care manager basically is a private social worker. Sometimes they're social workers, sometimes they're RNs, sometimes they're marriage and family counselors. Here, what the care manager does here is they go out and assess the needs, and they provide that social service component. Because, see, most trustees, they do a social service component, but they're not social workers. They're fiduciaries. By tying in it with a care manager that oftentimes will not only go out and check on the beneficiary and report back to the advisory committee and the trustee on a regular basis, but they'll form a relationship with the beneficiary, and they're able to make some incredibly valuable recommendations. And they'll often help with what's called a distribution plan. What we actually build into a lot of our trusts when they are actually under administration is that once a year, we want the advisory committee to work with the care manager, if there is that option, and the trustee to develop basically a budget for that year, so that everybody's clear what the trustee is going to do. We don't want the advisory committee overseeing every distribution, but basically what they do is they put together a plan and basically tell the trustee, you can follow that plan. If you have to go outside of that plan, we can always get back together. So the nice thing about the advisory committee is this is a good place for family and friends and siblings and that sort of thing, where they ultimately have the power of hiring and firing. And if they have that power, then once again, they can control the trustee. I don't care who the trustee is. But, I'm always looking at the long term. We may have the best trustee in the world, but those people could be gone tomorrow and somebody else could be in their place. And I did work with a trust company where I had to move every single trust because they changed their management and basically were not treating my beneficiaries the way I think my clients' loved ones should be treated. So out the door they went. Now this is a variation of this. We use this a lot here, especially for folks with behavioral health issues here, or if we're in a situation where instead of a committee we're going to have a single person. It's very similar. We're going to have a trustee. It could be a private professional fiduciary. It could be a corporate trustee. It could be a pooled trust, which we'll talk about a little bit later. They're going to manage the funds, make the distributions, keep the records. The care manager is going to be the primary person, especially if we're dealing with behavioral health. In a lot of cases, we want the interactions to be with the care manager, not with the trustee, especially if we're going to have some behavior issues and that sort of thing, because otherwise we can burn out that trustee pretty fast here. So we want to put the care manager, which is a social service professional, on the front line. And then the trust protector is going to have the power to hire and fire. We normally will limit them to hire and fire abilities, especially when we're dealing with behavioral health issues, because once again, the problem that we run into oftentimes is that we'll have somebody, let's say we have somebody with a bipolar disorder in their manic phase. All too often they'll just have the trustee until they give in, and once again, we're better off working with a care manager who can maybe work on some behavioral management and try to quell that behavior. And with that, the trust protector could be a family member, is only going to hire and fire and will not be involved in day-to-day operations. let's say, and one of the things that comes up for both of these, and one of these things you'd want to talk with Jennifer is, we have to make sure that the plan we're doing is really makes sense. So of course, when we're using professional trustees, they have the habit of charging for what they do. And so if you're using a corporate trustee, you probably should have a minimum of $500,000 in that trust. And this is why the insurance industry so many times is so involved with the special needs trust industry, because oftentimes families may not have the option of leaving that kind of money, and they might buy a life insurance policy to do it. For a private professional fiduciary, they usually don't have minimums, but realistically, if it isn't $200,000 or $300,000, you're probably not generating enough income off of the investments to cover the management costs. So let's say in this case, you would love to leave your child that kind of money, but really what you're going to do is leave them, for instance, a home that they're going to live in here, and maybe $100,000 on the side to make sure that home is maintained. And that's a plan we see all the time. I would tell you, housing is the number one issue, period. In that case, we might more narrowly tailor what this trust is going to do. And with that, we might even write in the trust that our primary focus is going to be making sure the house is maintained and making sure the utilities and everything is covered, and that we don't have a lot of money for Disneyland and going on wild trips. And in a case like that, if we really narrowly tailor it, maybe we might want to have co-trustees work with family members and that kind of thing. And then if you need some advisement, here, pay for it as you need it. But in a lot of those cases with these smaller trusts, the wisest thing to do, once again, in many cases, is get into a pattern of distributions, and they kind of have a life of their own. The last model I'll talk about, and just keep in mind, these are not the only models. If you're looking, these are just suggestions of models we've worked with that we think might work, is a pooled trust directed by a trust advisory committee. Now, I happen to be the trustee of the Golden State Pooled Trust, but in California we have many pooled trusts that are very fine trusts. What a pooled trust is, it's kind of like a cross between a 401k and a special needs trust. When you use a pooled trust in a traditional sense, what you do is you sign a joiner agreement, you sign a contract to join that trust, and then the funds go in that trust without a separate document here. And if you're talking with a smaller amount, that may be fine. But the problem with that, as far as I'm concerned, is if you do that, you have just limited your options. I have found as a planner over the years, you should do everything you can to not limit your options, both as far as how the trust might adjust, but also in trustee options. So, the pooled trust today that does a great job could be tomorrow's problem. Generally, if you have a trust of almost any size over $100,000, most pooled trusts will actually service the trustee rather than using a joiner agreement. So in that case, what we might be looking at is doing a separate trust and naming the pooled trust as the trustee here. And one of the reasons that we might choose the pooled trust is that, one, pooled trusts oftentimes share the resources of hundreds, if not thousands of families, and oftentimes they can provide more services at less cost because they're splitting the cost over a lot of folks. Some trusts actually have their own care managers here, or advocates that may be at a lower cost. So that might be another reason to do it. Ideally, the pooled trust is accountable to a family member or a circle of support. So it's not uncommon that what we'll do is create a separate trust with an advisory committee, and we might name, we just made this up, the Leaky Lagoon Pooled Trust. There is no such thing as the trustee. And what it's going to say is the trustee is the Leaky Lagoon Trust, or a private professional fiduciary, corporate trustee, or pooled trust of the advisory committee's choosing. That way, once again, if that's the right answer when you pass away, or if this goes into effect upon your incapacity, the advisory committee has a chance to really check to make sure this is the right group. But the other thing, as time goes on, if they either do not serve the beneficiary properly, or there could be a better option that comes down the road, you have the option of being able to change it from one pooled trust to another organization or whatever. And I'm here to tell you, and I've seen a lot of this just in my advocacy work. I know there's a lot of things coming down the pipeline because there's many families that are trying to provide this advocacy and support for their loved ones when they pass away here. And so there are many creative folks out there trying to find better options. And as those options are tested and proven, it's something that we certainly would want to have available even after you pass away. So the last part of the four-part process is funding the special needs trust. So consider the trust the vehicle, the trustee's the driver, but you got to put some fuel in that trust or it's not going to go very far. So there's a couple of things that come up. One of the biggest problems we see with estate planning in general, not just special needs trusts, is that a trust only acts on what is either in the trust or what is directed to the trust here. And so part of when you're choosing a good investment advisor to work with, if you're working with an investment advisor, it's not just whether or not they can put a good plan together. That certainly is important here, but the other part of that is a good investment advisor should assist you in making sure that all your beneficiary designations are correct and that kind of thing. One of the worst things that could happen is, like if you have a 401k or a pension or whatever, if you don't direct that the portion that would go to your disabled child's trust, if you don't do that and it's just left in the boilerplate, what's going to happen is those funds are going to go directly to your child. And if your child doesn't have capacity, not only is it going to mess up their benefits, but if they don't have capacity, it's going to mean that there's going to need to be a conservatorship of the estate. So now you have attorneys and judges managing your pension. It's just not the way to go. And keeping up those beneficiary designations is really, really important. So once again, part of this is there's many ways of funding the trust, and we will be doing a webinar later next month on some changes that have been going on with retirement plans called the Secure Act and that kind of thing. Funding the trust is really important. Not just how much and what you fund, but making sure that it's all done correctly. So here's the last step, which is update and review. A question I hear all the time is, how often should I have my special needs trust reviewed by an attorney? And I'll give you the typical attorney's answer: it depends. And it really does. Okay, now we actually have a webinar, which we are probably going to be redoing soon. We have 2 webinars which we encourage our clients to watch. The first one is updating your special needs trust. So it's a self-check. It's a self-review. And the second one is on updating your child's special needs trust, which is a self-review once again. And it kind of takes you through a step-by-step process of reviewing your trust. And after you're done with that, then you can come in and talk with Jennifer and the drafting team. And then they can help you really zone in on what do we really need to change. I will tell you what people mostly change. They rarely make major amendments to the trust. Usually what they're amending is who's going to be the trustee and where the fund's going to go when I pass away. So with that, there is some guidance. Now there is an article that I wrote here, which is here with the Special Needs Alliance, called basically, this is on creating an advisory committee that functions. Although this actually, and that's actually an error. Let me go back. The article is on updating your child's special needs trust and beginning with the self-review. So if you go to the Special Needs Alliance here and look and put in search, updating your child's special needs trust, this article will pop up. So begin with an annual review. My suggestion is that you pick one time a year you're going to open this thing up and take a look at it. It could be your child's birthday. I have a client who says, I always do it on the day that we sign the trust because I remember when I wrote you that big check. That motivates you, that's fine. Whatever it is that's going to stimulate it. And if you spend more than 15 or 20 minutes on this, you're putting too much time into it. But begin with an annual review that you undertake yourself or with the assistance of your financial or tax advisor who will help you with your overall financial planning. Once you perform this self-check, you will be able to determine if now really is the time to update your estate plan and your special needs trust. I would tell you, many of these trusts go a decade or more without really needing to review, as long as you're looking at it to make sure that's relevant. So you'd want to look at the sections having to do with who's the trustee, who's in charge if I become incapacitated, any special instructions along that line. That's usually what you're reviewing. It's also important that your financial or tax advisor know about all of your assets, not just what they're managing, including here. And one advantage of involving your advisor is that in an emergency or upon passing, they'll be able to better facilitate with your successor trustee to gain access to the assets. And also, a lot of the advisors we work with, a good advisor should know more than just your investment goals. They should really know your family goals. Common issues. Is my trust practical, right? Has there been some major changes in your own circumstances? If your finances have changed one way or the other, you may want to modify your plan accordingly. We've had many situations where maybe the plan was put together with the assumption that there would be X number of dollars, and maybe something comes up with your own health or that kind of thing, where with some unanticipated expenses, and at that point, that may be a point where you might want to come back and make an appointment with Jennifer and just review this and really look at, is this thing really practical with the finances you have? Sometimes finances go up at that point, and that's something where you might want to look at. You may want to rework the trust directives and memorandums of intent to reflect how you feel about how the trust should be managed as time goes on. You may also want to change the amount that you've allocated to the special needs trust and the portion of your estate plan you intend to leave to other family members. Once again, we go back to that impossible question about how do I divide up my assets between all of my loved ones, including my child that has a disability. Now, this will surprise you. Our prejudice is that your loved one with the disability has less options, so we usually suggest a little bit more for them. But, as time goes on, projecting the needs of a 17-year-old is a lot less accurate than projecting the needs of a 57-year-old, And so as they get older, we're going to have a better idea of what their time horizon is and, what our challenges are going to be. Have there been changes in my loved one's condition or benefits, including here government benefits, living arrangements, medical decisions, or support systems? Here, also we might look at advocacy programs. I know a lot of times here you may be really dependent on one family member or another to be that advocate, to be that person who is going to be there to collect that abuse and neglect. Here, and part of this should be looking at if there's any family conditions along that way, or if it's a sibling that has basically said they're doing it, but they're in a situation where they've moved away, or it's just not possible. You may want to rethink that. So, for instance, if a parent advocate is diagnosed with dementia and has a debilitating stroke, then it might be prudent to shift some of the advocacy duties to another family member, a private fiduciary, or a care manager. And by the way, I really suggest for a lot of our folks, as they get older here, to engage the care manager before you pass away. Here, that way, once again, when that transition comes, whether it's because of incapacity or death, we're not introducing a stranger to your disabled loved one. And the other thing is you can get to know the care manager so you can have a better idea about how that's going to work. I have to tell you, that's a really good thing to do as we get, more mature. Many family members serve as primary advocate for a loved one, but if there's a question regarding your ability to continue in that role, it's really important to have a really frank discussion. Here, I have to tell you, one thing that drew me into disability advocacy is, once again, I have experienced both in state hospitals and in the community too many instances of abuse that oftentimes goes undetected until something terrible, terrible happens. And it's really important that somebody be in tune. Both for your sake and that of your loved ones, you should make changes to your estate plan to anticipate the future inability to serve as the primary advocate, engaging a care manager both to assess the overall benefits and support network for a loved one, and to help a family plan for future contingencies is one of the most efficient, in many cases financially advantageous steps available. If I haven't been clear, care managers can be very, very valuable, and we're fortunate enough to have access to many care managers. And once again, whether you work with us or not, once again, we're fortunate in the East Bay area to have a lot of wonderful options, and we're always happy to share folks we're pleased with and all that. To end this, and actually there was a key slide that is not there. To end this and that, and we can take questions for about 20 minutes if we'd like. These are our websites, which is the Achieving Independence website and the Dale Law Firm website and the GSPT website. If there were sound problems or whatever, you can certainly go back and watch this later online. So anyway, Amy, what kind of question?
Okay, so there was a question about can you keep your SSI if you get SSDI?
You certainly can. Many folks, but it has to do with the SSI rate is $943 here, I believe, this year. So once again, if you've got SSDI, let's say $700, then that would reduce your SSI by $680. They don't count the first $20. And then once again, the rest would be SSI, and with that you would get Medi-Cal. That would be the same with childhood disability benefits. And we have many folks who get a combination of programs. If you're getting a combination of programs, then eventually you'll get Medicare and Medi-Cal. So you certainly can.
Okay. And then there was a question about ABLE accounts and how they work with special needs trusts.
Okay. We have lots of programs on ABLE accounts here. So you certainly can go to our YouTube website, and we'll make sure that people get that link. But yes, you can tie an ABLE account to a special needs trust. And oftentimes what we'll do, one of the advantages of an ABLE account, depending on the beneficiary, there's two advantages of it. One is if you pay money into an ABLE account, and let's say the ABLE account itself pays for food and shelter, what will happen is that because the money in the ABLE account actually belongs to the disabled individual, you will not take the $281 reduction in public benefits. So here would be an example. Let's say the rent is $1,000 a month. If the trust were to pay the rent directly, then the benefits would be reduced by $281 a month. Let's say instead the trustee paid the money to the ABLE account and the ABLE account paid the rent, there would be no reduction in benefits. The other advantage of an ABLE account is that an ABLE account here, especially if it's tied to a debit card. So for instance, we currently use the Ohio program. We will be suggesting using the Cal ABLE as soon as they have a card, but as of this date, there is no card here. So anyway, with the Ohio plan, you can put money on that card, and the beneficiary can use it however they like, and the trustee actually doesn't have to monitor it. And the nice thing about that is that at least they have a little control over their lives without having everything reviewed by the trustee. Do we have any questions from the audience here? And if we do, speak up.
Yeah, I have one about we were just talking about the childhood disability benefits first, when you transition from SSI to that. If you're fortunate enough or disfortunate enough to get a large amount because you have a parent that had a maximum amount coming in, you lose your SSI completely.
Yes.
And then that in turn means that in 2 years' time you go on to Medicare, and then you're in jeopardy then of trying to get Medi-Cal still with Medicare because you've got these higher child disabled benefits.
So let me show you how that works. Okay, is that of course we're waiting for the Medicare. You would still, if it's childhood disability benefits, you're still qualified for Medi-Cal no matter how much you get, but the rules are buried in a thing called the POMS, which is called the Program Operation Manual System. Social Security's not really good at naming things, so you'd think they'd give it a better name, but they didn't. So there is a POMS that basically says that if they were on SSI and then they go on childhood disability benefits and are knocked off of the program, they are to continue their Medi-Cal as if they were on SSI. Now, this may be shocking to some people, but Social Security makes a lot of mistakes, and we run into cases all the time when they should be getting Medi-Cal, but they're not. But the only other thing, if you're on Medi-Cal, even in that situation, you're still subject in that case to the $2,000 resource rule and the income rules as well. We have many, many people that are getting childhood disability benefits and still getting their Medi-Cal here. The other thing that comes up is that you get the benefits from either parent, and it's basically whatever gets you the most. You don't get to add them together. So you might have a situation where maybe mom was the breadwinner, but maybe dad retires first, so the child will start getting it based on dad, and then maybe mom here passes away, which gets a larger number, so it'll switch over to that person. Although Social Security is supposed to pick that up, yeah, you really have to be on top of that when you have that kind of change. The other thing I'll just mention as far as this is concerned, this is not a gift to the child from the parent. This is an entitlement. So let's say we have a situation that happens way too often. Maybe dad, when the child is born, says, well, I didn't sign up for having a child with a severe disability. I'm out of here. Here we call them scumbags. Here, maybe they do that. Here, well, it's still, when dad retires, becomes disabled, or passes away, that's still his child, even if he never paid $1 of child support, never met his obligations. The child is still eligible for those benefits. Childhood disability benefits are incredibly important. They are much friendlier than SSI. I will say for the vast majority of our beneficiaries who have severe disabilities, giving up the Medi-Cal is just not something that's reasonable, so we have to work at maintaining both, which can be done.
Medi-Cal want to charge you, whereas you've been on Medi-Cal, which hasn't been charging you a premium. So the trick is trying to get Medi-Cal to pick up the Medicare.
And which they will. They will pay the co-pays, and there'll be no share of cost if it's done right. And if Social Security does what they're supposed to do. So there's a lot of factors. Amy, do we have another question from?
What happens if a child is eligible for childhood disability benefits based on the parent's working record, but they have a job where they're earning $1,300 a month? Then what happens?
Well, the issue we'd have to do is we're still dealing with whether or not the child is disabled, right? Because it's not just whether or not they have a diagnosis, it's whether or not they actually meet the definition of disability. Now, despite the fact that, once again, I don't do eligibility work, you actually do eligibility work. SGA is 1260 this year, isn't it? So despite the fact that the measure is whether or not you earn 1260, there's a bunch of other factors, including what are called IRWIs and things like that. So really, to get more information, I still think the best place to go is disabilitybenefits101.org for that. There are also articles on the Special Needs Alliance website, which is specialneedsalliance.org, on this. Amy, I know you've been a student of this. I mean, it's no secret that you do this work because you have a personal interest because of a loved one here, and you've been studying this for a number of years, and these are not easy issues, right?
They are not easy.
They're not easy issues, right? So, take way in the back, and then.
In regards to sufficient record keeping for distributions out of a special needs trust in a manner that is satisfactory to SSA, could you please give me an example of sufficient record keeping beyond tossing receipts into a shoebox?
Right. Okay. So, for instance, here's an example. A lot of times we'll have the beneficiary either have a credit card or a family member with a credit card who will rack up expenses, or there's a thing called a TrueLink card, which is a special card that's been recognized by Social Security that can be tied to the trust and given to the beneficiary and all of that. So let's say the what we have is an expenditure at Target for $100. Well, when Social Security is reviewing this, how do they know if there's food there? How do they know what that was purchased for? Since we're talking about third-party trusts, we don't care about gifts. But the concern is going to be, did they buy food? And if you go to a place like Target, they might have bought food. And so not only do they need to know what the expenditure is, they need to know what it was for. Now, if you go to Shell Gas and you buy gas at the pump, it's pretty certain you bought gas. So, I mean, you don't, there's a certain point. Or if you have an expenditure to Comcast for cable, that's certainly self-identifiable. But the thing about it is, and I will tell you, we are in Region 9, which, as far as I'm concerned, is one of the toughest Social Security regions in the country. There's an argument that Region 5 may be in competition for tough, but I think Region 9 is pretty tough. They have really committed they're going to review every expenditure of every single trust, which is nothing to be afraid of as long as you keep really good records. But part of it, what's really important, is to be able to account not just for the amount, but to be able to identify what it was for. Sometimes the expenditure itself will do the job, but sometimes not. Does that make sense?
It does. It's that like equivalent to like a Schedule C for 1099s?
Yes, much the same way. But once again, you work with some of these agencies. They're a little bit on the anal side.
Yeah.
Here, they're crazy on the anal side right now, and which is tough because, once again, the eligibility workers are crazy overworked, and where they're finding time to go through pages and pages of expenditures, I don't know, but they're doing it, and that's what's going on. This is one of those areas where being a little paranoid is probably warranted, so there you go. You had a question? Yes.
In doing my research, I have found separate kingdoms, and it's been very hard for me to think through the links. So in the old days, the family attorney would draw up a trust and might manage it and be the executor over time, having known me, met my children, know my intentions. I'm told that's the exception rather than the rule now because of potential conflict of interest.
Right. And there's a lot of rules along that line. There are some attorneys who do that. I am the trustee for the Golden State Pool Trust, but we have a pretty strict rule around here. I'm either the attorney, or we're the attorney, or we're the trustee. We don't do both, right, because of the conflict.
In that regard, my adult son is disabled, lives in Sonoma County. I have not been able to find a care manager in Sonoma County who, as a result of wanting to be care manager, also wants to be the fiduciary.
I'll tell you about fiduciaries and private fiduciaries here, and I'm a big fan of private fiduciaries here. Private fiduciaries usually come from two places. They either come from the financial world or they come from the social service world. It's either one or the other here. Some fiduciaries, I can think of some, although I'm not sure who it would be in Sonoma specifically here. But I know many fiduciaries who really their strength is more on the social service side. A lot of times we find ourselves dividing out the care manager from the fiduciary. If you can find somebody who does a decent job doing both, all the better. The only other thing you have to look at is, sometimes cost. I will mention one thing that we're working on, and in Sonoma County this will be rolling out this year. We have been involved with a program called the Life Passage Planning Program. There is a group called Bayberry Inc., which is a supported living services agency, and their primary work that they do, their core work, is working with regional center clients, persons with intellectual and developmental disabilities, to do what are called supported living services, which is basically what the supported living services are, is that if you have somebody with a developmental disability living in their own home, under the Lanterman Act, they're entitled to services, whatever services are necessary to keep them safe in the home. And that's what these agencies do. They go out and visit, they'll make sure the benefits are, they'll go out and, in many cases, If there's a benefits issue, they go to Social Security with them, they go to the doctors. I get the same thing for my beneficiaries. I'll get a beneficiary that'll go to the doctors and go, what the doctors say, and they'll go, I don't know. Well, that's not very helpful, right? They go to Social Security and go, what does Social Security say? And they'll go, I don't know. And, once again, that's not very helpful for me either. Whereas when I have one of these agencies, and basically the rate they're looking at charging right now is $60 an hour. And so they're actually doing a lot of work. And so they're working in Sonoma, Napa, and Lake, and Solano counties. Another agency that's doing the same thing, and this will just emphasize what I was saying, is that systems for providing care in the community are changing. And this is an example, because once again, we love care managers, but care managers will tend to charge about $150 an hour. Now, going out and doing assessments and things like that, that's fine. But doing the day-to-day stuff, you can imagine how you could run through a trust pretty quick at $150 an hour. So once again, in Marin County, the program that's doing this and has been doing a great job is a group called ICS. And in Alameda County and parts of Contra Costa County, a group called EBI is doing this. And as this program, which was funded by the May and Stanley Smith Charitable Trust, here as this pilot program expands, we expect to see these programs expand through the state. Now, here's how this is going to work, and I'll give you an example of somebody we're working with right now. We have somebody with severe cerebral palsy, has all sorts of medical issues and that sort of thing, who has lived in their parents' house their entire life. The parents recently passed away and sadly had to move out of the house into a facility. We are hiring a care manager. We're actually, in this case, we're hiring a group called National Care Advisors, who will be going out and evaluating our beneficiary about their medical needs and that kind of thing, and putting a plan together, working with the trustee. A lot of the work is going to be delegated to EBI here, who is going to be doing a lot of the day-to-day stuff, like visiting on a regular basis, reporting back, taking them to appointments, going and purchasing things, making sure the receipts are in good shape. Here, they actually will go if there's an issue with Social Security. In this case, this beneficiary wouldn't herself go to Social Security, but if she did and needed to for a review, she'd go to Social Security. So by having the agency working with the care manager, with the trustee making the distributions, we're able to really zone in on what that person needs. I think the greatest need out there in the community is affordable, competent case management. Tracking the benefits and keeping folks qualified for benefits, that's certainly an important thing to do. But if you think about it, the real thing is keeping your eye on these folks and making sure they're safe, and making sure that, and a lot of folks with disabilities, especially many with developmental disabilities, oftentimes here have a hard time expressing themselves when there's a problem. Here we had somebody where something terrible was going on, but he's always happy and jolly, so he always has a smile on his face, although as we checked later, there were some things going on that somebody should have picked up, and I know the parents would have picked that up. And so having somebody in touch with those cues, somebody who visits them on a regular basis, and somebody they trust, is just huge. Really, it just adds a whole dimension to the trust, And I think, once again, it's one of the most valuable things we can provide. I'm not saying that we have a perfect situation. We're in development of this, but I will tell you, it's not just the Dale Law Firm, but there's many folks that are really dedicated to that. There must be a better way. The nice thing about this Life Passage Planning program, and I encourage anybody that's interested, email, and I'm going to pick on you, Amy, A-M-Y, at DaleLawFirm.com, and I know she would be happy to put people in touch with these programs and learn more about this. We'll be doing more programs. Case management, whether through a care manager, we might have a fiduciary who actually does decent care management. They do exist. Or through one of these agencies. I think it's an essential part of doing a decent plan. Now, there are some situations where the beneficiary can service their own advocate themselves, and you really have to evaluate the situation. Like I said, the pleasure and the problem with this is these are all individuals, right? So unfortunately, I can't pull off your plan and give it to you. I wish I could. Here, it would sure make things a lot easier. You really have to individualize these things. With that, we probably could take a question or two more. Otherwise,
Now, this is something that I think you can address. It says that one person says that they have a living trust that includes a special needs trust in it. If I can prepare as much detail as a special needs trust within my living trust, wouldn't it be the same?
that's one approach, and I'm not saying that's incorrect. In our office, we're always going to do a separate trust. Always, 95% of the time, we're going to do a separate trust. Why? And by the way, we don't charge any different here. Whether it's what we call an embedded trust or a sub-trust or an individual trust. One of the advantages of an individual trust is, let's go back to my niece. We do have the Erica Mott Trust, and if you'd like to leave something in the Erica Mott Trust, which I think I'm not allowed to do that because of state bar things, but there is a trust. Now here's the thing. We have a separate trust that, my wife and I fund, and also aunts and uncles. Maybe there might be a nephew out there that might do the same here. By having an individual trust, we have a pot that people can put their funds in. If it's a sub-trust out of my living trust, first off, it's not going to occur until I pass away. And secondly, there's a pretty good chance that my in-laws won't be too wild about putting their assets into my estate plan. The other thing with it is, especially in California, with a trust, everybody who's named as a possible beneficiary in that trust, even if you name a charity here, gets a right to a copy of that trust. In your living trust, and not a portion of the trust, the entire trust. So in a case like this, these are usually very personal trusts. So when you pass away, everybody who's named in your living trust is going to get a copy of that trust here, including the sub-trust. If we instead have a separate special needs trust, we're going to limit who's going to be able to get access to that document. The last thing is that the function of a special needs trust is, I think, is very different than a living trust. And sometimes it gets really confusing. A lot of the language that's in a living trust that needs to be there in language in a special needs trust, I personally think it's just a lot cleaner just to have a separate trust. That's not to say that if you have a sub-trust, or what we call an embedded trust in your living trust, it's incorrect. But I can tell you it didn't come out of the Dale Law Firm, because we just don't do that. So there you go. So basically what we have is language that says whatever's going to go to Helen is going to go to Helen's Special Needs Trust. And then the other thing that we're probably going to put into it is in the living trust that any distributions for Helen, if I become incapacitated, will be in accordance to the guidelines in Helen's Special Needs Trust. And I think we're down to, we'll take this as our last question.
It's about special needs trust. I think you said any money that's left, say my son has a special needs trust, he passes away for his older sister, there's still money left in his special needs trust account. That money can go, who can say where it goes?
Well, the answer is twofold. It could be you or it could be the beneficiary. So let's look at it two ways. And here's where the confusion comes. There are two types of special needs trusts. We've been talking about estate planning trusts. The other kind of trust is what's called a self-settled trust. It's a trust where, let's say your child got a settlement, okay, and you could put it into the different type of trust. It's called a first-party trust. I like to call it a Medi-Cal payback trust. But on those trusts, you're making a deal with the government. Basically, let my child keep their public benefits, and if there's any money left, we'll pay back any Medi-Cal your child has used during your lifetime. And if they've used even a moderate amount of Medi-Cal, that's going to be everything. So that often gets confused with the third-party trust. The third-party trust has no payback. By the way, it's not subject to creditors. So that's the other nice thing about it. So if your child gets sued, they can't get their hands on it. So you can either name who the remainder beneficiary is, or the other thing is, if your child has capacity, you can actually put in what's called a power of appointment. You can say, child, when you pass away, you can make a will, and with the help of an attorney, and you can actually say whatever is left in the child can go to who I want it to go to. So if you have a child that's competent, the odd thing is they can't control it while they're alive, but they can control it when they pass away, right? So normally, once again, it's one of those situations you could leave it to a sibling, you could leave it to a nonprofit, and this is probably a good place to leave today. Here is that, a lot of the advances in the community and a lot of our hope in the future is working through groups like the ARC, NAMI, Best Buddies. There's so many different disability organizations. Even a small contribution to them when you pass away is really going to help other families and other persons with disabilities, and all that. So I really would urge you and encourage you here to leave something to folks. With that, we're going to end today. I want to thank you today for watching. Here, we'll try to get there will be some editing on this, so we'll try to get this back on the website as quick as possible. If you're interested in working with us here, if you go to the Dale Law Firm website, to the contact part, you can enter in a request for the intake sheet and everything to do with Special Needs Trust. For those of you that are filling out your blue sheets today, if you'd like an appointment, that would be great, or give a call. The process will go through, and if you have some questions that you need answered, because the goal is to not answer every question, but if you have some sort of burning question that you really need to have fleshed out before you're ready to get started, here, certainly you can make an appointment or make a call, and we'll do our best to answer that question. Our goal is for you to be as prepared as possible when you sit down with Jennifer and Lysandra here, one, so that you can go through a process, with a base of knowledge here. And it also, we have found that it actually reduces the amount of time that our staff put into this by a couple of hours, so we're really passing some of the savings on to you. And the way the process works is that you come in with your intake sheet filled in here, and bring your checkbook here, and then once again you'll sign an engagement letter. You'll meet with Jennifer, who will work with you on designing your trust. That will be passed on to Lysandra, who will work with initially putting the trust together, and then Jennifer will work to customize it. Then what will happen when that part is ready is that we send usually a draft via PDF to you and go over that with you, and we highlight the key parts you need to go through. There's a lot of boilerplate with it, and I'm not saying you shouldn't go through it, but it's really not a great, terrific use of time. Really, what you really focus on is who's going to be in charge, what is this trust doing, here, and where does it go when you pass away, and those sort of things, to make sure that's all correct and all that. And then after that's done, in most cases, if you're coming into the office, you'll come in, and it's not unusual that there's some changes in the office, have it signed, and once again, and that's usually the process. We are able to do them. If you don't live in the immediate area, we are able to do your estate planning here as well. And if you already are working with an attorney, and if you have a perfectly good living trust, we're not looking at replacing that. We're more than happy to work with you and do the Special Needs Trust. And then what we'll do is we'll work with your attorney and have them make a change to your living trust, basically to say whatever's going to your child will go into the Special Needs Trust that we drafted. And so, once again, if you are working with an estate planning attorney that you're happy with them, we're not looking at taking other people's clients. And so that's something we are more than happy to work with your estate planning attorney. With that, I want to thank you for attending tonight here. Happy advocating, and good night.